Dangerous navigation in grievous bodily harm is an offence under Section 52B of the Crimes Act 1900, which carries a maximum penalty of 7 years in prison. To establish the offence, the prosecution must prove beyond reasonable doubt that 1. You were navigating a vessel. 2. You were involved in an impact causing grievous bodily harm to another person. And 3. You were under the influence of alcohol or a drug or drugs, or were navigating at a dangerous speed, or were navigating in a dangerous manner. A vessel means a watercraft of any description that is used, or capable of being used, as a means of transportation on water. An impact is that which occurs through 1. The vessel overturning or running aground. 2. An impact with any object or person in the vessel. 3. An impact with another vessel. 4. An impact with anything attached to the vessel. 5. Falling from or being ejected or thrown from the vessel. And 6. An impact between any object, including grounds and water, and a person due to the person protruding from the vessel. Grievous bodily harm means really serious harm. It includes, but is not limited to: 1. The destruction of a fetus other than by a medical procedure. 2. Any permanent or serious disfiguring. And 3. Any grievous bodily disease. The maximum penalty increases to 11 years in prison where the offence occurs in circumstances of aggravation, which is where 1. You had a prescribed concentration of alcohol in your breath or blood. 2. You exceeded the speed limit. 3. You were attempting pursuit by a police officer. Or 4. You were very substantially impaired by a drug or drugs. A prescribed concentration of alcohol PCA is a reading of at least 0.15. You are presumed to have been under the influence of alcohol where you had the PCA in your bloodstream. A certificate of your alcohol or drug concentration is admissible as evidence as long as the analysis occurred within 2 hours after the impact, unless you are able to prove on the balance of probabilities that the concentration was lower at the time of impact. A defence to the charge is that the harm was not attributable in any way to 1. Being under the influence of alcohol or drugs. 2. The speed at which you navigated. Or 3. The manner in which you navigated. Duress, necessity and self-defence are legal defences to the charge. In the event you are able to raise evidence of a legal defence, the onus then shifts to the prosecution to prove beyond a reasonable doubt that the defence does not apply in the circumstances of the case. You are entitled to an acquittal if the prosecution is unable to do this.
Going to court. Call Sydney Criminal Lawyers on 9261 881 to arrange a free first conference. Watch our latest video here.